Hello, everyone. Good evening. Good evening. Please, can we all hear me? Please, good evening. Can we all hear me? Please, can someone confirm that they can hear me? Good evening, everyone. Can we all hear me?
Yes, I can hear you.
Hello,
I
can we
can
all
hear
hear
you.
me?
Yes, sir.
All right. Thank you very much. Good evening, everyone. Welcome to the JIIPCC Mentorship and Internship program. Um, we are in our week two of this exciting program, and so far it has been very interesting getting to hear from our mentors in week one, and we'll be continuing with today, week two. Our topic for today is mediation and career opportunities in mediation. We'll be starting off like soon, very soon. Sorry, I'm just trying to still keep up with our setup. But not to waste any time, what we will do right about now before we commence the class proper is to head into introducing our mentors for today. So for today's class, we are expecting to have three mentors, right? And I'm sure they will be doing well to share their insights as well as give us proper insights, well as give us proper, a more in-depth insights into mediation, as coming from, the previous week where we did an introduction into ADR. So our first mentor for today is, well, no stranger to us, is Mr. Nyacham Nawan. Mr. Nyacham Nawan is a lawyer and the principal partner of a law firm, N. Nyacham and Co., a law firm based in Kaduna, Nigeria. He's a certified teacher, trainer, and facilitator. He is a faculty member of the executive director of the Settlement House ADR Training Institute, an institute for training certificates and training for the training, certification, and practice of ADR, alternative dispute resolution. He is also a member as well as faculty member of the Nigerian Institute of Chartered Arbitrators, a model arbitration certification institute in Nigeria. He is a certified dispute resolution specialist, an international mediation campus trained mediator, an attorney mediator, a certified mediation advocate, an arbitrator, a certified negotiation, an ADR practitioner, a restorative justice practitioner, and a certified emotional intelligence specialist. He is a certified conflict manager, a certified ADR's registry/secretary, a holder of Mediation Academy, United Kingdom, certified in commercial mediation, accredited by the Institute of Chartered Arbitrators UK, a medical law enthusiast, an employment and labor law expert. He's an accredited and trained mediator with Accord International, India, and has completed a course to become a Florida Supreme Court certified county mediator in the United States of America. He served as a judge and expert assessor in many international mediation and negotiation competition. He has mentored many students and non-students in the theory and practice of ADR. He has a keen interest in the application of ADR in the resolution of medical negligence disputes, workplace disputes, commercial mediation, faith-based disputes, land disputes, family disputes, amongst others. He, as a dispute resolution specialist, he has handled several disputes which were amicably settled out of court. He is willing and ready to volunteer for the contrib- for and willing to volunteer for and contribute to the development and practice of alternative dispute resolution. He is a facilitator for the professional diploma in education of Institute of Education, Ahmadu Bello University Zaria, as well as an external facilitator with the Federal Polytechnic Kaduna. He is married to his wife and blessed with two children. Thank you so much, Mr. Nyacham, for everything you do for us. We are always happy to have you in class, and you are very much welcome. Our second mentor for today is our lovely mentor, Miss Natalia Odidika Eziobo. Essay Zobo. Sorry, Ma, for not pronouncing your name very well. Ms. Natalia is a distinguished legal practitioner, accredited mediator, speaker, and author of Seven Steps to Handle Depression that many don't know. She has contributed scholarly articles on alternative dispute resolution to various journals as the formal and principal partner of nativity attorney practitioners, mediators, and mediation advocates. She leads a firm dedicated to providing expert legal and mediation service. Additionally, she is a creator and host of Legal Moments with Nat, a weekly live program on Facebook where she offers free legal guidance to help individuals navigate legal challenges. Renowned for her expertise, she has mentored mediators undergoing training at the Lagos Multi-Door Courthouse and guides law students across Africa, Asia, and Europe. She has also contributed to an expert as an expert assessor and judge in numerous virtual mediation and negotiation competitions at both local and international levels. Multiple certifications and accolades from esteemed institutions worldwide reinforce her extensive experience in dispute resolution. Natalia is an active member of several esteemed professional organizations, including the Nigerian Bar Association and the MBA section of Business Law, where she currently serves as the Assistant Secretary of the Employment, Labor and Industrial Relation Committee. She is also a distinguished member of the Employment and Labor Lawyers Association of Nigeria and a trained mediator on the panel of neutrals for the Lagos Multi-Door Courthouse, Kaduna Multi-Door Courthouse, Nigerian Chambers of Commerce Dispute Resolution Center, and Nigerian Deposit Insurance Corporation, amongst others. Additionally, she is a member of the Continuing Legal Education Committee of the MBA Lagos branch. She currently serves as the General Secretary of the National Association of Catholic Lawyers, Lagos Archdiocese, and was recently appointed by the NBA as a member of the Local Government Monitoring Committee. Natalia dedication to serve others extends beyond her legal practice and has earned her numerous accolades. Her passion for peace building and advocacy led to her training and appointments as a South Soul HWPL Peace Educator and Ambassador for the African region. Her skilled communicators, her skilled communicator, a skilled communicator. Natalia is fluent in Igbo, English, and Yoruba with a basic understanding of Hausa and Sign language. Outside her professional commitments, she pursues diverse interests, including public speaking, training facilitation, coaching, events moderation, traveling, marathon running, singing, and playing football. She can be reached at, okay, so this is Miss Natalia's email address, natalia.odika@gmail.com, and this is her LinkedIn profile as well as the address um, to her attorney's page. You're welcome. You are very, very much welcome, Ma. We are happy to have you in class. Thank you so much for joining in. Our last but not least of our mentors for today is Miss Omotayo Blessing Uwene. Uwune, sorry. Miss Omotayo Blessing is a highly experienced legal practitioner and mediator with over 15 years of expertise in soliciting advocacy, corporate law, and property consultancy. A dedicated professional, she has built a distinguished career in legal research, drafting, and alternative dispute resolution. Omotayo obtained her LLB from the University of Jos in 2008 and was caught in the Nigerian bar in 2009. She later earned an LLM from the same institution in 2018. She is currently pursuing her PhD in law, she began her legal career as the Court of Appeal Jos during her National Youth Service Corps program, where she honed her skills in legal research and drafting. Over the years, she has worked with reputable law firms, including Solis Chambers and Leo M. Ibe and Co., before establishing herself as a private legal practitioner in 2021. Her passion for alternative dispute resolution led her to become a certified mediator with the Settlement House Training Institute, SHATI, with a strong commitment to justice and effective conflict resolution. Omotayo continues to provide top-notch legal services and mediation expertise. She's based in Jos, Plateau State, and can be reached via email. So this is Miss Omotayo's email at babylawyer83.gmail.com All right. So thank you so much, Miss Omotaya, for joining. I can see you're already here with us. It's a pleasure having you here with us in class. We'll be getting straight into the business of today, right? Okay. From the way we started the last class, I think it will be safe for us to continue in like manner, right? I want for us to have presentations from our mentees first, and then we'll go on to our mentors to give us an introduction into the topic and also their discourse, and then we'll continue from them on with questions and answers. Then we'll call it a draw or a wrap to the session. So please, we would like to take presentations from the mentees. So group one, right? Please, if you're ready with your presentation, please kindly come up, share your slides, make your presentation, and let's carry on with the rest of class. So group one, if you're with us, the presenter for group one, if you're with us, please kindly share your screen and let's get on with the presentation. Do we have the presenter for group one in class? All right, thank you, Emelda. Please, you can go ahead and start your presentation.
Okay. Good evening, everyone. I don't know if everyone can hear me. Good evening, everyone.
Yes, we can hear you.
Okay, my name is Emelda, and I'll be presenting on behalf of Group 1. So, last week, we learned that mediation is one of the ADR mechanisms. So today we'll be looking at career opportunities in mediation, principles of mediation, stages and processes of mediation, agreement to mediate, and its significances.
Sorry, Dennis. Can you
Can
hear
you all
me?
hear me? Yes, I can hear you.
Dennis,
I can hear you.
is
Can you
only
hear me?
one group that submitted. Is it only one group that is presenting?
I just know for my group 1, and we submitted our presentation before time, our slides before time.
Dennis, you are muted.
Okay, group two were okay. It was group one that submitted. Group two did not submit their work, right? So we'll be taking presentations from group one. For group two, we'll be addressing the submission issues from their end. I think their group leader was unavailable. That's why they did not make their presentation.
Okay, but the group 2, are they around? Are they in? Do we have any group 2 member here?
I think we do. Okay. Perpetual.
Are you the presenter for group 2? Alpha. Okay, I move for. Can you speak? Okay, the presenter for group 2 is here. Do you have your slides?
Yes, sir. Good evening. Yes, I have the slides.
You have. You have your slides?
Yes, sir.
Okay, so share it with Mr. Dennis. Well, group 1 continues.
Okay, sir.
All right. Thank you very much, Perpetua. So the slides did not get through to me, and I wasn't able to access it from anybody from the group. But we'll be taking presentations from group 2 also. So, but Emelda, please, you can carry on with your presentation.
Okay. Thank you. Like I was saying, today we'll be looking at career opportunities in mediation, principles of mediation, stages and processes of mediation, agreement to mediate and its significances, then terms of settlement. Then under career opportunities in mediation, we have mediator for court-ordered matters. Basically, this is a mediation process mandated by a court where parties involved in legal disputes are required to participate in mediation before proceeding to trial. Then we have family mediator. This has to do with issues arising from family disputes, example, divorce, child custody, parental agreements, and the rest. Then we have workplace and employment mediator. This mediator has to do with issues arising from workplaces, example, sexual harassment, unfair dismissal, and the likes. Then we have corporate and commercial mediator. This is a mediator, is a neutral person who helps resolve business disputes and conflicts between companies, partners, shareholders, and the rest. Then we have school and education mediator. These are mediators involved in issues arising from schools. Example, let's say we have a dispute between a parent and a teacher, or a student and a student. Basically, that's where they come in. Then we have community mediator. A community mediator is involved in issues arising from communities. It could be communal disputes between a community and a community, or at times it has to do with, let's say, landlord and tenant issues. Then we have insurance mediator. An insurance mediator is a neutral person who helps resolve disputes arising from insurance deals. Then we have online or virtual mediator. An online or virtual mediator is a neutral person who facilitates dispute resolution and negotiation processes remotely. This person must not be at the scene of the issue, but person, because of technology and the rest, the person can get involved. Then we have mediator, trainer, or educator. These are mediators who help train students or those interested in mediation generally. Then we have principles of mediation. These are basically, this means guidelines in mediation. The first on our list is voluntariness. One of the features of ADR is voluntariness. Parties are not forced. It's something that both parties agree to take part in. So for mediation to be there, there must be voluntariness from both parties. Then we have impartiality or neutrality. Basically, the mediator must be impartial and neutral, meaning that a mediator, it will be unfair to favor a particular party against the other party. So neutrality must always be there at every point throughout the mediation. Then we have confidentiality. Mediation discussions are confidential, meaning everything shared during the process remains private, and the mediator is bound to maintain confidentiality. Then the next is self-determination. Self-determination basically means that the parties are in charge. The parties decide what to discuss, and they decide on their agreements. Then the next on our list is good faith, fostering cooperation. All parties are expected to enter the mediation with sincere desire to reach a resolution. The aim of mediation should be to resolve disputes and not to escalate it. Then the next on our list is stages and processes in mediation. The first stage is introduction and opening statement. This is where you just meet and greet. The mediator introduces himself, the parties meet themselves, and they set ground rules. And the mediator sets ground rules on how the mediation process is going to go through. Then the next one is information gathering. Basically, this is where the disputing parties state their issues, more like state their facts. The mediator is supposed to listen to both sides. Both parties are to say their own side of the story and where the shoe hurts without interruption. Then the next one is like issues identification and agenda setting. After both parties say their story, the next thing is for issues to be determined. What is the bone of contention? Why are you people quarreling? So basically, just to identify the issues and to set agenda on how the mediation, on how the dispute will be resolved. Then the next is negotiation and exploration of options. The parties would discuss on how the dispute will be settled amicably. Basically, the mediator is not supposed to impose, he's not supposed to tell them what to do. What the mediator is to do is to facilitate communication between both parties so that they will reach an agreement that will be favorable to both parties. Then the next thing is agreement drafting. Agreement drafting is after an agreement has been reached, it should be penned down by the mediator, ensuring that the terms are clear, specific, and mutually acceptable by the disputing parties. Then the next is closure and moving forward. So this is practically the end of the mediation process. Then the next on our list is agreement to mediate and its significance. Agreement to mediate is a contract that outlines parties' commitment to participate in mediation. So basically, it's just parties are saying if there's a dispute, we are going to resort to mediation. That's what it means. It's a contract and it's binding on both parties, saying that if there's a dispute arising from, let's say, this business deal, we are going to resort to mediation. Then the significance of an agreement to mediate is that it sets clear expectations, reinforces the voluntary nature of the process, then establishes confidentiality and defines the mediator's role. Then the last on our slide is terms of. Hello, can you all hear me? Can you all hear me?
Yes, go ahead.
Okay, the next is terms of settlement in mediation. Terms of settlement in mediation is a written agreement that outlines the specific conditions, obligations, and responsibilities of each parties involved in disputes reached through, in this instance, mediation. So basically, it's just when parties reach an agreement during mediation, the terms of the agreement are formalized in a settlement agreement. Then the purpose of a settlement agreement, it formalizes the agreement, it provides clarity, then enforceability. Then key elements of settlement agreement, we have like features of a settlement agreement: identification of parties, description of the disputes. Then terms of settlement. What are the terms of the settlement? Instances could be payments, amount and schedules, transfer of property, specific performance of certain actions, confidentiality, release of claims. So this
Emalda, are you still with us?
yeah, I think. Can you all hear me?
Yeah, we can hear you. Your screen is no longer sharing. Please, you can go ahead, share your screen and continue with your presentation. Okay, are you back with us?
Yes, I'm back. I'm trying to share my screen. Sorry.
All right.
Okay, wait. Beautiful. Sorry. Okay, I'm back. So the next on our slide is practically conclusion of everything I've been saying. So it still covers the career opportunities, the stages of mediation, the principles guiding mediation, and the rest. So I think this is all we have for the presentation. Thank you. Then the next is references. Thanks.
All right, thank you so much. Thank you so much, Amalda, for that presentation from your end. Well done to you and your team members for putting that together. We really do appreciate the efforts you guys put into the work. Group 2, you guys said you could have your presentation here. So please, group presenter for Group 2, that is Perpetual. Are you still with us? Okay, Perpetual, please, you can go ahead, share your slides and start your presentation. Emalda, please, you can stop sharing your screen. Perpetual, are you with us?
Good evening. Yes, I am. I'm trying to share the screen.
All right, please go ahead.
Okay, so good evening, everyone. My name is Petra. I'm from. I hope you can hear. I don't know if I'm audible.
We can't really hear you, and your screen is not up. Your slides are not up.
Okay.
Okay, please, can we try to rush that up quickly so that we don't waste too much time trying to get that ready? If you can, just send the slides to me on WhatsApp. I would help you share the slides on the screen so that you can continue with the presentation. Perpetua, are you with us?
Yes, I've sent it to you.
All right. So please go ahead and start your introduction. I would start sharing my slides soon.
Okay, good evening, everybody. My name is Petra. I'm from Group 2. So we are supposed to discuss mediation and career opportunities, but ours is not focused on career opportunities. So the first content on my slide is I did a brief introduction to career opportunities in mediation, and then next we're supposed to talk about terms of settlement. So in a mediation process, the parties come together and agree on a particular decision which is binding on both parties. Then they take this decision to the court, they file it, and then this decision is entered as consent judgment. So sometimes you go to the court, you hear that the matter for today is adoption of terms of settlement. So terms of settlement is an agreement between both parties that they have decided that such agreement should be binding, and they agree and undertake to ensure that such decision is binding on them and it is entered as a consent judgment. Then next we're to discuss on a mediation clause. So a mediation clause is inserted into a mediation agreement, and according to the Cambridge Dictionary, sorry, okay, and according to the, so a mediation clause is inserted into the mediation agreement, and this is important because in the event of any disputes arising out of the agreement, the parties would first resort to one of the alternative dispute resolution mechanisms, and in this case, it's the mediation. And also, the mediation clause should contain what language the mediation is supposed to be in, what the area that the mediation is supposed to take place in. You can also appoint a mediator, you should also have a governing law. And in this case, for Nigeria, we can refer to the Arbitration and Mediation Act 2023. So in the PowerPoint slides, I have two samples of a mediation clause. So the first one, it says, in the event of any dispute arising in relation to this agreement, the parties shall first resort to mediation. A qualified mediator shall be selected by the parties, and the mediation shall be governed by the Arbitration and Mediation Act 2023. So this is the first sample of a mediation clause. And then the second sample says, all disputes, controversies, or differences arising out of or in connection with this contract, including any question regarding its existence, validity, or termination, may, notwithstanding the commencement of any proceeding, be referred to mediation for the time being in force. So we're to draft a sample mediation clause. And also we're to speak on the relevance of a mediation clause. So the mediation clause is important in a mediation agreement because it promotes the effectiveness of the process. It ensures that the parties really undertake to make sure that the process is binding on both sides. And they also state out the methods of dispute resolution, their participation in the process, and the likes. So next, we're to discuss on an agreement to mediate and also a sample draft of this agreement. So this is a sample draft of an agreement to mediate. It states the commencement date, the parties involved, the mediator. You also see the fact that the mediation should be confidential, what language it should be in, that the parties undertake to abide by it. You state when the agreement was made and the date it contains. And we're also supposed to talk about deadlocks in mediation. So deadlocks are, sorry?
I'm sorry to interrupt you. I'm struggling to hear you. Could you please a little bit more audible? Thank you.
Sorry, was it from like the beginning or can you hear now?
What did you say?
Sorry, I was asking if it was from the beginning.
No, just a few seconds back.
Oh, okay. So I will start from, I think, a mediation clause, maybe.
Okay, yeah. Okay, go ahead.
Okay, thank you. So one of the things we were supposed to discuss in book 2 was a mediation clause and its relevance. So I said the mediation clause is inserted into the mediation agreement, and it is relevant because it makes the parties undertake, it states various things such as the fact that the process is binding between both of them, methods of dispute resolution, the parties undertake to participate in the process, right? And then I spoke about 2 different samples of the mediation clause. The mediation clause states what language the mediation agreement is supposed to be in, the seat of the mediation process. So yeah, those are different things that are contained in the mediation clause. Then next, we're supposed to speak on an agreement to mediate and also draft a sample agreement to mediate. So an agreement to mediate is a contract entered into by parties to a mediation agreement, and it contains, so you can find a mediation clause in the mediation agreement, basically. So this agreement to mediate is also called a mediation agreement. And then this is a sample draft. You state the dates it is to take effect, you state the parties, you state where it is supposed to take place, you state the particulars of both parties and also the mediator. You also state the fact that the agreement should be confidential and other things that the parties undertake to do in the agreement. And then the final thing we're supposed to discuss was deadlocks in a mediation agreement. So deadlocks are it's like a standstill to a mediation process, and then ways you can avoid or ways you can resolve such things are that first the mediator should identify what caused the issue. Then the mediation should be proactive in resolving it. He should call both parties, you talk it through openly, and then you see how it can be resolved. So I think that's the all that was supposed to talk about. Thank you.
All right, thank you very much, Perpetual, for helping us with that presentation. Well done to you and to your team members for putting that in, even though you did not submit on time. Hopefully, in the next class, we're able to make adjustments so that we can submit our presentation on time and also send to the mentors for them to also review. So before we go ahead to hand over to our mentors for their comments and also their discourse on today's topic, mediation and career opportunities, for the sake of lightning in the background for us to take pictures, I would like to kindly ask for those who are in class to kindly turn on their videos so that we can take a quick screenshot of class. So please, if you can, and if you're in a location with good lighting, please turn on your videos. Let's take a quick picture and we'll get back to class. We'll do that in just a minute and then head over back to class. So please, if you're on call, please can you kindly turn on your video? Thank you, Pina. Do we still have more mentees on call? Please kindly turn on your videos. Thank you, Mr. Abdul Basit. Thank you, Perpetual. All right. So we're still going to take a little bit more. Imelda, thank you very much. All right. I think that's fine. So thank you all for cooperating. We'll be going back to the class and we have our mentors here with us ready to run us through what we have for today. Like I said, our topic for today is mediation and career opportunities. So Mr. Nyacham, if you're with us, over to you, sir. You're welcome. Mr. Nyacham, are you with us, sir?
Did you get the snapshot?
Yes, I did.
Yeah?
I said I did, sir.
Did you get the snapshot?
I said I did.
Okay, you share with us. Okay,
All right, sir.
you share it with us on the group. All right. So thank you very much for that. You can share kindly share this thing for group 2. Kindly share the presentation for group 2. All right, so
So your network seems to be breaking. No, we cannot. I think your video is interrupting with your network, sir. Mr. Nyacham, are you with us? Hello, Mr. Nyacham, are you with us? Okay, Mr. Nyacham seems to have left class. I'm sure he'll be joining us shortly. So while we wait for him to come back to class, I think we'll just kindly hand the class over back to our two other mentors that are here with us. That is Mrs. Natalia and Mrs. Omotayo. So I think we'll be starting first with Ms. Natalia. We want to just quickly get feedback from you on the presentation and also your discourse into today's topic, mediation and career opportunities, and then we'll hand over to Ms. Omotayo. So Ms. Natalia, if you're with us, please, I would like to get your discourse on the topic.
Okay, good evening, everyone. Thank you, Dennis. You're doing a good job moderating the session. Can you hear me clearly?
Yes, ma'am, we can hear you loud and clear.
Okay, I'll ask that my video remain muted because the network is really horrible. I'm sure that's what Nanshang is struggling with right now. So I listened to the presenters and I will commend them. Well done. So while you were talking, I have a few questions to ask the presenters. So my question is, let me start with the first presenter. You talked about the ground rules and why it is essential, why introducing introduction and what's the process of mediation. And you talked about the first part, which is introduction. And while you're explaining, you had mentioned the ground rules. So here's my question. What's the difference between, okay, first of all, have you heard about agenda setting in mediation? Have you heard about that? Hello? Can you hear me?
Yes, ma'am, I've heard. Yes, ma'am, I've heard about
Yes.
agenda setting.
Okay, so what's the difference between agenda setting and the ground rules?
Okay, agenda setting, I think is the end game of the mediation, basically like what they would love to achieve. Then ground rules basically just maybe the conduct throughout the mediation process. I'm not very sure.
Okay, thank you. How about the second presenter? What do you know about agenda setting and the ground rules? Or maybe tell me what you know by agenda setting. See, there's no perfect answer. I mean, there's no correct answer. There's no wrong answer. We're all here to learn. We're all here to learn. And you'll be amazed that I may even be learning from you, even though I'm your mentor, right? So there's no right or wrong answer. So I want this session to be interactive. So I'm asking the second presenter the difference between, what you understand by agenda setting.
Okay, agenda setting is more of laying the foundation towards the mediation process.
Okay, so when you say laying the foundation, how do you mean?
So the parties, the mediator sets the tone for the agreement. The parties
Okay. So let's not dwell much on it. You guys have an idea, and you use the word just tone. So the agenda sets the tone for the mediation process as a whole. And Imelda also talked about how it goes. Yes. So the difference between it and ground rules is that, most times or sometimes you find out that some mediation sessions are very anxious. And so emotions are charged up. And if you remember when I told at the last session, I don't know if you attended the last week, when I mentioned that the role of the mediator, besides facilitating, you must manage the emotions of the parties. So if you're having a family mediation session, or you're having a commercial transaction where has been breached, so the emotions are likely to be charged, or where one person feel being cheated, emotions will be charged up. So as the mediator, who is the manager of the process, you are expected to help the parties manage their emotions. So what the ground rule does is to set the rules and regulations that will guide the process of the mediation, so that when parties are going off, you remind them of the ground rules. It means, one, they cannot interrupt when someone is talking. They cannot shout. They cannot, use their phones. They cannot record. All those rules, so that you can have a seamless and uninterrupted mediation session. However, when it comes to agenda setting, like you both said, it dictates how the entire process will go. It sets the tone. The agenda will tell the parties, today, this is what we are supposed to do. We're going to spend 2 hours, and this is how we're going to spend those 2 hours. I will allow parties to speak for 10 to 15 minutes each, and then we'll carry on. And then in the agenda setting, you ask them about their expectations as well. How would they want it? What do they intend to achieve out of the process? So when you have all of this clearly stated, you're being guided as the mediator. I would say that much as the agenda setting guides the process, sets the tone, as it were, it also helps you, the mediator. I think it's more for the mediator than the parties, in the sense that it helps you to manage your process well. And so if you are veering off the agenda, you bring yourself to order. And then when you see that the parties are also going off, you also bring them. So the agenda setting dictates the entire tone of the entire process. And also in the agenda comes the ground rules as well, because in trying to set the tone and how everything is going to be, you now remind them of that process, as it were. And the parts are actually guided. Now, I've listened to fantastic presentation from both groups. There's no need, we all know what mediation is all about, so there's really no need overflogging it. Importantly is, whatever you do, remember the confidentiality. And like I mentioned last week, confidentiality is not only within the joint session, even in private sessions, you must maintain confidentiality. The impartiality, it's not about you saying I'm impartial, I'm not biased, and all of that. The parties must see from not just the words of your mouth, but from your conduct, that you are truly impartial. You're not taking sides, but you're there to help the parties, guide them. And even in trying to resolve the issue between the parties, you must maintain that neutrality throughout. The parties must see it. Voluntary, it is the parties. Your role is to do reality checks. I was hoping that someone would mention reality testing. Now, as much as the mediator cannot tell the parties what to do, as much as the mediator cannot give a binding decision, parties, mediator has a duty to do what we call the reality testing. You must test the choices being made, the proposals, the choices that the parties themselves are making. So somebody looking at the whole case, for instance, you see that this person deserves about, what the person had actually written or is asking for is about 5 million. And then the person comes to the mediation session and is demanding for 10 million. That is ridiculous. Why you cannot tell the parties, no, you cannot demand for 10 million. What you should be asking for is 5 million. Why you cannot do that as a mediator? But you can ask them, how realistic is this your option? You're testing them. You're pointing their minds to go towards that path, to see that, okay, without even saying it to them, you have indirectly, through your questioning skills, pointed the parties to that, reality. That, oh, what you're demanding for is ridiculous. Your questioning skills will point to that without you telling them that they are ridiculous. It's very important that you hone your questioning skills, right? And don't forget about the flexibility of the process. So importantly, while we talk about career in mediation, you cannot talk about career without mentioning or understanding the role of a mediator. Before I go on, I want to ask, can you all hear me?
Yes, ma'am, we can hear you.
Okay. And then secondly, then is how long am I supposed to speak for? I don't want to take too much time so that Amotayo can speak as well before Nanchan can come back.
All right, you have 15 minutes now.
Stop sharing the screen, please. Stop sharing.
Okay. Okay, so please let me know when my 15 minutes is up. So basically, right, the role of the mediator is very important. Like I said the last time, a mediator is responsible for facilitating communication between the parties. You are there to facilitate communication. One, you are there to clarify any issues. So, and that's why when parties have finished their presentation as a mediator, if you're not sure of anything, you clarify. If you ask them by reiterating those things they have said, ask them questions for clarity, because sometimes you may think you understand, meanwhile you don't understand. As a good mediator, you must clarify, you must summarize, and when you do that, you ask the parties, does this capture what you have said? They will either tell you yes or they will tell you no. And then as a mediator, you have to encourage dialogue. Remember, you are there to facilitate communication. Your parties must be talking and not you doing the talking. And that's why I said, allow the parties to speak for 80 minutes while you, the mediator, speak for 20 minutes. So to say, you're helping them. And you cannot say you're a mediator and one party is talking, the other one is not talking. That's where there's a power imbalance. And you, as a mediator, must help to resolve that. Now, as a mediator, you're helping the parties to find a common ground. And so you're setting the ground rules, you're ensuring that the discussion is respectful. You are helping the parties to identify their interests and their concerns. You're suggesting solutions and compromises. By suggesting here, we're not saying you must tell them. There's the Med app where Medcon rather, and the Med app where you can actually suggest things to parties. Why don't you look at it this way? But as in the mediation, you are actually pointing them through your questioning, your open-ended questions. Can you tell me more? And then, okay, why don't you look at it this way? Have you thought about it this way? You're asking those questions, and parties are actually aligning themselves, trying to understand. Remember, with mediation, is a win-win. You let go of some, you embrace some. That's where everybody goes happy, unlike litigation, where most times one party takes it all. And then you, as a mediator, must draft the agreements that reflect what the parties have agreed. If what you have drafted does not reflect what the parties, then all the time you've spent has been a wasted effort. And then, because we're talking about career in mediation, if you don't have these essential skills, for instance, you cannot have a good, you can actually have a good career in mediation distance. So for you to be a successful mediation, you must possess a combination of soft skills and professional expertise. Active listening, we cannot overemphasize this. Understanding what each party is saying and reflecting back on their concerns is very key for you as a mediator. If you don't have the active listening skills, believe me, you can't go far in your mediation career. Emotional intelligence. What happens when there's a problem in your mediation room? How do you tame the emotions of the parties? How do you manage the emotions? How do you foster, that empathy? And then your communication skills. Mr. H says to you in private session, this man is a useless man. He's a very stupid man and wicked. You cannot go back and tell Mr. B, Mr. A said you are stupid. He said you are very useless. Once you do that, you have ended up further escalating the problem between the parties. Because rather than focus on the issue they want to resolve, he will consider the insults. Now, you as the mediator have not communicated it well. Even if the other person says, you're very stupid, tell him he's stupid. You cannot go and tell him, I should tell you are stupid. You could tell him that Mr. A says he's not happy the way things are. He's not happy how you have, how he's not happy the way that this matter has come between you guys. There's a way you present it, and then it sounds pleasant that even if you're passing that message across, this other person understands that you are giving that. You must articulate ideas clearly, and you must, facilitate that effective discussions between them. As a mediator, you must have a problem-solving ability. Be able, when parties present their matters to you during the opening sessions, right, then you have to be able to identify the root causes of conflicts and proposing creative solutions. There's been times when parties are not even concerned about what brought them. Maybe they are dragging money. But if you look deeper, the only thing holding them is the ego. During my training, mentorship training, I had a situation where the party, I had a situation whereby can you still hear me?
Yes, we can, Ma.
Yes. Where we had two sons who came for mediation session. So those sons, what was in their way was not even the property that was worth over 150 million back then. It was the ego. Oh, this person was rude to me. So rather than they representing their parties that they came with, they are more focused about their ego. So as a mediator, you must do what? Be able to identify those things, deal with them, and then you're able to resolve the main issues. And then be patient. Some parties, I must tell you, when you finally become a mediator, some parties are very frustrating. It's like they prepare to come and frustrate the efforts of the mediator. And if you're not careful, as a mediator, even the best mediator can be ridiculed by a party. They can rubbish all your efforts. So you learn to be patient, maintain that composure and that fairness throughout the process. And then in talking about career opportunities, the presenters actually did a fantastic work in that regard. So I won't dwell much on it. There are different careers. All what's important is identify your niche. What is it that you can do best? Your area of interest. Develop yourself in that area and be a subject matter expert. It could be a family mediator. It could be a personal injury. Like while we were reading that Nan Chang's profile, I heard you mention the aspect of his interest in medical injury mediation. It's an area you can decide to go in that route. Workplace, and you could do that within the employment environment. Some organizations hire mediators to come and train their staff. You could actually become, if it's in the workplace, how to resolve this sexual harassment and all of that. You could come about and be able to say, okay, this is what I can do, and develop yourself in that area, and you see yourself building your career. But importantly, you must be patient even with yourself. Sometimes you're going to find yourself messing up and you're asking yourself, do I even know what I'm doing? We all have experienced that at one time or the other, but you must keep on pushing. And that's why you will need to continuously be trained, attend webinars, attend trainings, anything that has to do with ADR, be involved in it. Your peers are there, you can learn from them, look out for mentors, even as I mean, we've been in the process for some time. We still have mentors that we look up to. Interactive session in the group where you belong, that have ADR experts. Ask questions, reach out to them, whether it's on LinkedIn, on Facebook, wherever you find them. Ask questions. You are building. And I must tell you that ADR is dynamic. So what you think you know today, tomorrow it's no more. It's something that's entirely. You must constantly improve yourself. That's why continuous education is very important. And so there's the aspect of online dispute resolution. What happens when you cannot meet physically? And then if you come online, how do you manage the emotions of the parties? It's very key. These are things you have to learn. Obtain relevant education and training, gain experience, volunteer with community mediation programs, assist senior mediators as their apprentices and learn from them, participate in mock mediation exercises, be accredited, join your local bar associations, dispute resolution centers, visit there, provide your own opinion, learn from them. That way you build yourself, and then you also have to market yourself and build a reputation. Project yourself into the market. Talk about what you do. When you talk about it, people will know. Now, I have some organizations who reach out to me because it's some of my work. I have a weakness, and that is always posting the things. I do a lot of things in the background, but I've not had time to be posting them. There's a lot I do, but I've not had time. But those who have seen me, I have a private session on my WhatsApp, on Facebook, but on LinkedIn, I don't post all the time. I see people reach out to me, So if you don't put yourself out there, nobody will project you. So finally, network with lawyers, network with non-lawyers, HR professionals, industry experts. That's where you build yourself. So thank you very much. Before I end, I have a question again for the presenters. I think it was the second presenter who mentioned impasse. So I want to ask this question, not just to the second presenter, but for both of them. How do you break an impasse? That's the question. How do you break an impasse? Thank you. I'm waiting. And any other person on the call too can answer it, because not just the presenters, because I know you are like a good number of you in the group. So don't leave it to the presenters alone. I think I should leave the presenters and ask the other persons there. What do you understand by the word impasse? It's a group work. I believe you all work together. What do you understand by impasse, and how do you break the impasse? That's the final part of my own section. Thank you. I'm waiting for your answers. You can drop them in the chat box as well.
All right, mentees, please, we can kindly cooperate and answer Ms. Natalia's questions so that we can move on.
All right. Okay, so thank you very much for that wonderful contribution, Ms. Natalia. It has always been a pleasure having you around. We have another mentor in the house, Omotola. Are you here with us?
Yes, sir.
All right. So we had a very interesting time listening to. I had a very interesting time listening to the participants, and it's actually very, very interesting. I like, they have done perfectly well, but group one, who was the presenter for that group one?
It was, if I'm not mistaken, the group presenter was Malda.
Are you still with us? Presenter for group 1.
Are you still with us, Imelda?
Is she still with us?
Yes, I'm still here. I'm still here, sir.
Okay, so first, you people have done a wonderful work. From the content, it was great and superb. But it seems you people went to download it directly from online or something, or using any of these AI tools. Is that correct? Hello? Hello? Can you hear me? Hello?
We can hear you.
Can anybody hear me?
Yeah.
Yes, sir.
Yes, we can hear you, sir.
Okay. So what I observed for group 1, it seems they got their content directly from AI. I want them to confirm for me. Group 1.
We are with you, sir.
I know you are with me. I want to know. You got your content from
No, sir.
you went use AI tool and then got your content directly because it's nice, but you see a lot of other things. Okay.
No.
Group. That's okay. Am I a member of group 1? Okay, group 1. Yes, go ahead.
Okay,
Did
sir.
you
I said
participate
it.
in the preparation?
We did not copy directly from AI, sir.
Did you participate in the preparation?
Hey, can I speak?
Who, please?
Sorry, can you hear me?
Yes.
Okay.
Who is
Good
speaking?
evening, house. I don't know.
Good evening. Yes, who is speaking?
Audible.
We can't hear you. Your voice is breaking. Okay, so without.
Hello. Okay. Good evening. I'm Amanda. I'm a member of Group 1.
Okay.
Can I speak now?
Go ahead, please. We can hear you.
Okay, no problem. Good evening. I'm a member of Group 1. My name is Amanda. I compiled the material also for my group. Okay. So majority of what is in the material is from my own contribution to the group.
Okay.
Okay. For your question in regards to the material being more artificial intelligence, I'll actually decount that, sir, if I will. Okay. Other than participating in the program, I'm also a certified mediator through Institute of Chartered Mediators and Conciliators. And we have materials that were given to us during our program. That's where I get majority of my work from for the different articles and group work we are given.
All right. Thank you for that contribution.
Thank you very much.
Okay, so we have group 1. They looked at career opportunities in mediation, and I think they've done a wonderful work. If you have questions, you can put them down so that you will use the opportunity to ask important and relevant questions that may add value to you. So from mediation, career opportunities in mediation. Okay, so principles of mediation. Principles of mediation. Okay, so group one were able to help us see the principles of mediation, and they've captured some of the important points that needed to be stated, and then the presenter also did very well. So we see number one, we saw number one, voluntariness. By being voluntary, by voluntariness, we simply mean the parties are not compelled to the mediation table. Putting mediation is the fact that can't compel the parties. So they have that have their own different reasoning. So believe that we should amend our court. Oh yes, our court, our laws should put parties to take part in mediation. Should put parties to take part in mediation. On the other hand, some school of thought were of the opinion that if you compel people to take part in mediation, what happens to the principle of voluntariness? And beside that, you can actually, like the saying goes, you can force a horse to a river, but you cannot you can take the horse to the river, but you cannot force the horse to take water. So assuming you succeed in forcing parties to come for the mediation table, you will not also force them to continue with the discussion at the mediation table. So that is very, very important for us to know when it has to do with the principles of voluntariness. Voluntariness in the sense that it is the parties that are the discussion, the parties that will end up deciding for themselves to see them in discussing to the point where they get either resolve their disputes or have a better understanding of their disputes. So that's about the issue of voluntariness. It's very, very crucial and very, very key. I've had a mediation session before, and then one of the parties filed a notice of preliminary objection. If you are a lawyer, you understand that the party filed a notice of preliminary objection, and that they are not submitting to the jurisdiction of the court of the mediator. So it's actually a strange procedure, but it's just a simple indication of the fact that we are not willing to submit, like lawyer will say, we are not willing to submit to the jurisdiction of the court. And so when one party is invited for a mediation session
Hello, Mr. Nyacham. Okay, I think Mr. Nyacham is having some network issues. I'm sure he'll be joining us shortly.
I want to suggest that while we wait for him to come back on, perhaps Mr. Motayo is here, so she can carry on.
Okay, but currently he's back on.
Can you hear me?
Thank you, sir, for joining us back.
Can you hear me?
Yes, sir, we can hear
Yes,
you.
Nanchan, welcome back.
All right, thank you very much. So now, when you understand the concept of voluntariness, bringing the parties to the table has to be on their own voluntariness. They have to be willing and ready to do so. Because once, no matter how willing a party is, once the other party is unwilling, that brings the mediation to the end. And that is actually what happened in the story I was trying to tell you in my own personal case, where a lawyer filed a notice of preliminary objection. So eventually, we have to let the parties go. Now, where you are appointed as a mediator,
Yes, sir, Yacham, you're muted. Okay.
so impartiality as a principle, you know, the thing is that you have to help them because parties are coming voluntarily. They can at any point in time decide that they are not interested. So they can come and participate at the point they say they are no more interested. So for you to be able to keep them at the table, you must also ensure that you treat them equally. You know, for example, there is in the course of mediation, you come to a point where you may need to go for caucusing. Caucusing is an opportunity for you to ask, do reality testing. Like one of our mentor was saying that, that's the time for you to go to ask difficult questions among several other things. So you want to get to understand something that the party is not willing to share, in the presence of the other party. So when you are doing that, you must allocate equal time. Let's say you give 5 minutes to one party, also give 5 minutes to the other party. By the time you are spending 10 minutes, while you have given one party 5 minutes, it has already shown that there is inequality, there is imbalance there. So you have to be very careful. So by the time you smile for one party and you are not smiling for the other party, that will indicate impartiality. It means that you are partial, so to say. Why will you smile for one person and not smile for the other? When one person comes in, you stood up and shake the person. Then when the other one comes in, you just sat down and then stretch your hand to shake the person. That's indication of partiality. And if you are not careful, it can just destroy your mediation session and then say, I don't think I'm safe here. That's the thing. So you must ensure that you are neutral, you are unbiased, and let the parties know that you don't have any interest in the outcome of their negotiation or their discussion. You are just there as a third party neutral to facilitate or assist them to discuss to the point where they may find a solution or understand their differences better. Now, another principle that they mention is confidentiality. Confidentiality is key. In fact, it's the bedrock. Now, for you to get parties to begin to share and discuss with confidence, you want to assure them, see, anything we discuss here remains here. And anybody that is here, whether it is your counsel or the parties themselves or the mediator, everything we discuss here remains here. Like the new law, the Arbitration and Mediation Act 2023 clearly says that, in fact, it now clearly says that you cannot even invite a mediator. You cannot invite a mediator to testify. So you see, when you discuss documents, you bring out facts or circumstances or things that was used during the mediation table, the concept of the principle of confidentiality covers it. So you cannot, because somebody has confessed during the mediation and say, oh yes, I did this thing because of this reason. Then when mediation fails, then you can now use that evidence in court to say, but he confessed. All of those conversations are without prejudice. And, so when you say that parties will feel free to discuss because everything you discuss remains here, there is this kind of confidence, a booster that it gives the parties. so that they will feel that also anything I say here, they cannot use it against me tomorrow. They feel very happy and excited to share, their mind. So that is very, very important for you to note confidentiality. But you need to note something. I personally also I enrolled in a training also by another institute to also become their own certified or accredited mediator, and I discovered that one of the emphasis that was also made is the fact that confidentiality stops where criminality begins. So you have a duty and responsibility. Let's say in the course of mediation session, somebody confessed that I will certainly kill this person. I will certainly rape her. That is a confession that is going to commit a crime. Are you bound by confidentiality? In that circumstance, so is that actually brings an end the issue of confidentiality. So you have a duty and you have a responsibility. You have a duty and you have a responsibility. You have a duty and you have a responsibility to report that matter, so that you will not be you will not be a contributor to that fact. You should not be a contributor, to the crime of the party. So confidentiality is very, very key and is very, very important, but it has its own limits. When it has to do with crimes, when it has to do with possibly maybe there is an order of court asking you to, when it has to do with crime and then an order of court to say, please provide us with so and so for the purpose of our investigation and the rest of it. But generally speaking, except where there is issue of crime, you are not bound. You are not bound at all. So that is very, very important. Now, that was mentioned here, is the issue of self-determination. So you see, the emphasis when you are giving your opening statement is to help the party understand that, see, I am not a judge here. I'm just a third party who is here to assist you find a solution for your problems. So if that is the situation, you need to help them understand that they have the right to actually stop the mediation at any point in time, and the decision making is actually theirs. Like one of our mentors will say, when he did a mediation session and then eventually the party settled and they say, oh, wonderful, this mediator is good that he has settled them. He now said, no, sorry, I am not the one who settled them. They are the one who settled themselves. They are the one who actually decided the matter for themselves, because that is the principle of self-determination. They determine what happens. They are the one who will choose the mediator. They are the one who will discuss in the process of the negotiation. They are the one who will decide and craft for themselves the solution that best fits them. So that's the very, very important thing that I need to get. We're looking at generally career opportunities. We're looking at mediation and then the career opportunities and mediation. And the principles is very, very, the principles are key ingredients of those things. So now, having said so, they mentioned the issue of stages. The stages are just simple. In one of our faculty meetings, I had the privilege of teaching for some ADR organizations, and then for Nigerian Institute of Chartered Arbitrators, in one of our faculty meetings, an argument erupted as to whether you have 5 stages of mediation. Must you follow the 5 stages of mediation? And then some of us are of the opinion that no, it is not mandatory, but the stages are there as a guide. it is not something that you must follow hook, line, and sinker. Please confirm to me if we are together.
Yes, sir, we're together, sir.
Mr. Dennis, I want to confirm if the others, I can see that almost up to 5 people have left or thereabout. We are up to 14. Hello, I'm talking to the mentees. Are we together?
We're together.
Hello?
I can hear you.
Hello?
We are together. We are together, sir.
Okay. So when it has to do with the processes and stages of mediation, for example, you have first, you need to understand, you need to prepare. Then after preparation, what do you do during preparation? Okay, we have a mediation session. What do? You find what is the time that we're going to meet? What are the facts of this case? Where are we going to meet? What place are we going to meet? What time are we going to meet? If I'm an appointed mediator, by which organization? How much am I going to be paid? Is it a free mediation? So these are things you need to find out in the preparation. So sometimes you can call preliminary meeting by the party so that you can agree on these things. How do we go about it? Is it on daily basis so that we should sit down and discuss from morning till night until we all settle? These are preparation stage. Then when you finish all the arrangement and you come for the mediation session, what do? You have you are going to have the first meeting. So in that first meeting, what happens is that parties give their opening statements. Now, you need to know that the opening statement of the mediator is very, very key and very, very important, because when the mediator did not give a good opening statement, the parties may, to some extent, be left confused. They will be wondering, what is it? Is it another judge that is coming to give verdict after we finish speaking, or what is it? So your opening statement as a mediator, you are going to introduce yourself. If you have been trained, if you have been in the system for a while, introduce yourself and make those things known. And after you do that, you tell them to introduce themselves and find out how they wish or want to be addressed. So I will tell you that I am Mr. Nanchang and you can call me Mr. Mediator. That is what is very important, to find out how parties want to be addressed at the opening stage of the mediation. Because somebody has suffered so well and he has taken up to 10 years to get a doctorate degree and he attached it to his name. And then when you come, you say, you are a white man, or you have been trained, you have been staying abroad, titles are not important, and you decide to call the person without his title. You may end up destroying the process in its entirety. So this is what you need to know. Find out from party, how do you want me to how do you want me to address you in the course of this mediation? They say, call me Dr. Professor something, right? You see, you have cleared that stage. So afterwards, you will now tell them that, okay, find out from them whether they have been in a mediation session. If they have not, but whether they have been in a mediation session before, they have not, help them to understand what mediation really means. You are there, you are not a judge. You are there to help and facilitate the discussion between the parties, between them. So the discussion is going to be done by them. The decision is going to be theirs. But you are going to be there as an expert who understand the processes and the stages, and with your expertise, you will guide them to find a solution where possible for their problems. So explain to them what it entails. Set down certain rules. And then I always encourage people to actually have a collaborative way of setting out the rules. Don't come as a mediator and tell them that, okay, put your phone, don't call, don't answer, don't do that. So you can say, like, okay, now for us to have a meaningful conversation, it would be good for us to adhere to certain rules. Like, for example, will it be proper or will it be okay for us to be that when one person is speaking, let the other party keep quiet. And then if, for example, the person says something that you feel is not true or that you want to respond, instead of responding, there and then, you can take note so that when it is your own time to speak, you can now speak and address those issues. Is that something you think we can? Please, I want to be seeing our faces, so if it is possible, so that it will not be as if I'm speaking to myself. Those who can put on their cameras, please do. Now, what I'm trying to say is that when you have a situation, somebody asks you of your opinion, you think this is something we should do? Say, oh yes, we can go on like this. Do you get? You will be like, oh, that's wonderful. Okay, we agree. So the decision is ours. You will not feel as if it was imposed on you. That's collectively. So what I'm saying is that when you are setting the rules for the mediation, set it collectively. Try to see that the parties participate and agree to it. Don't just give them instruction because you are the mediator. You may end up, spoiling the thing at the end of it. So, but take note. Collaborative, set the rules. Okay, we don't want to interrupt, and then use of verbal. A husband or a wife can wake up and say, "You are a very useless man. I know you from the beginning. I don't know why I even got married to you in the first place." When situations like that come, you say, "Okay, do we agree that we should avoid the use of offensive words, things that can insults among several others?" What we agree, you say yes, we agree. So if you do it collectively, you can at the end from them, please, do you have any other thing that you think we can add up as rules that will help us to have a very meaningful and uninterruptive session? And then they'll say, oh, yes, so because they know each other, they say, and when I'm talking, this person will be like this. When I'm talking, all of them, let them at the end of it, explain to them, you're going to have a caucus, so that they will not be wondering, what are they doing? What are they talking about when they are alone there? Explain to them what caucus means, so that when it is time for caucus, they will not be what do you give me here? And then you are discussing with that person alone. Explain to them in your opening statement. I say it's important because it sets the course of the mediation and give the parties an understanding of what it is and the expectation and the process. Once you do that, the parties now give their opening statement. Yes, thank you very much, Natalia, for that. So at the end of it, at the opening stage, once that is done, the parties now give their opening statement. The opening statement will be the side of the story and what they want from the mediation. Now, this is what you should take note. When party A finish making his opening statement, that is what we call the statement. If I get you ready, I understand what you are saying. You said this, you said this, that you want it and see. And say, oh, you see now this, meaning that you got you got very excited. That's what you should.
It's breaking bad. Your network is breaking badly, sir. But it's clear now.
Okay, thank you. So now, once that is done, when he finished stating it, he said, okay, I'm if I get you, and this is what you said, and this is what you want. Having said that is their position. For example, they will tell you that you have to pay me 10 million damages for what you have done for this and that. These are positions that they have taken. Now, from all that they have discussed, we advise that you should try to form an agenda for the discussion. When you have a agenda, that will be important, because just like the meetings that we book on, we have agenda, move from agenda 1, 2, 3, what.
Mr. Nyacham, your network is still breaking. Hello, sir.
Please confirm.
For my end, your network is breaking. Yes, I can hear you, but your network is cracking. Yes, sir, we can hear you now.
Okay, so what I said is that try to agenda, and agenda helps you understand what this like that. For example, and I put it for you. The woman is talking about career. Then that is and then you okay, husband. Today the issue. And the other party is talking about we are before we got married. So I'm not ready to discuss anything about having them now. You see, as much as that is very important, it cannot form part of your agenda, because the party is not really discuss that issue. Okay, that part I will discuss an issue and agree. Let's put it down for me. You didn't do what I had to. Please talk on what is an agenda. I collected the money. And if whether you should don't do what you collect the money for, it's not the agenda that you should discuss. Whatever you agenda, something now when you push because one of those issues, one after the other, that you see them when law, most
The network problem will be persisting. So sir, please, can you kindly turn off your video? Maybe that will make it better.
Can you hear me now?
Yes, it's much better now, sir.
Okay, so what I'm saying is that, let's say for example, the issue is a woman tells you, a woman says that, please confirm if you can hear me.
We can hear you loud and clear, sir.
Yes, better now.
Okay, so now a woman tells you that the man does not love me anymore, and that is one of the issues at the mediation table. And then you see, during exploration, you have identified agenda, and then you are picking one issue first. The woman say, I want divorce. Okay, divorce is one of the agenda, and you pick divorce. Okay, can you tell me more? Why will you want to go for a divorce? Say, the man does not love me, he does not care for me, he does not do this, and that. He tells you all the story. And then you want to explore more. You know, when you do certification training, like somebody says she has done ICMC certification training, they will teach you about questioning techniques. Just like lawyers, questioning is one of the tools that mediators use. You can ask questions about opening, you can ask open questions, you can ask closed questions. So sometimes you want the person to talk and explain. Remember that where conflict succeeds, there will be breakdown in communication. So most times you see between husband and wife, communication is not moving as it's supposed to. But when you come to the mediation table and they say everybody should be allowed to speak, the woman is excited. The man is happy that he can now say everything he wants to say without interruption. it gives you an opportunity to do so. So by the time you are explaining, you want to ask questions that will give the parties opportunity to talk and to, oh, can you tell me more? So what happened? And then from there, what you know? So you want the person to talk and talk. At some point, after the person finishes speaking, you will discover that on its own, the dispute may get resolved. Why? Because sometimes conflict comes because the parties wanted to speak their mind, but they don't have the opportunity to speak their mind. So now they have the opportunity and they shared their burden, especially for women. They have shared what is disturbing them. At the end of it, what do you want? You see a sign of relief. You know, their mind, you know, they have talked, they have said their mind, they have shared what is disturbing them. The husband is not giving them listening ear. You are exploring. When you explore, you get to understand the reason why the conflict is the way it is. Because sometimes, most time, people speak positionally. They just, this is my position, I want divorce. That is the position. Why do you want divorce? You go for exploration. By the time you start exploring and digging, you get to understand the reason for the divorce. And then from there, you will now begin to pick out issues and matters that you feel these are the sustainers, these are the pillars of the conflict. And once you are able to crash them, the parties will be able to resolve their differences. So these are the things you do from exploration. You now identify the issues, you know, there, you know, that you need to sort out. So when a woman says he does not love me, you want to find out what is love to you. And she tells you that before, when he's coming back from work, he used to buy shawarma for me. Now, for the past 1 year, 2 years, he has stopped buying shawarma. And to her, that is the definition of love. So you must not assume when somebody says something you don't understand, seek clarification, ask the person to explain, give you examples, and all of those things. Then the person, when you finish all of those things, then you now understand. When this person says he does not love me, what he means is that you were doing something before and you stopped doing it, and so that is an indication I don't want to continue in the marriage because you no longer love me. Another person will be that she was not beating me before, but now he has started beating me. That is the definition of he does not love me. So it is only during exploration that you get to understand all of these things. And when you are able to identify these issues, you know, you can easily harness them together and you get the other person perspective. Say, no, she became rude. You know, she was talking to me anyhow. Remember, mediation, you have to listen to both sides. And so that is it about the processes. By the time you discuss, sometimes you discover that after exploring, you discover that all that the party needs, they say this person is arrogant, he's so pompous, and that is why the conflict escalated. Maybe the party just need, okay, I'm sorry. That could be the issue that will solve the problem, you know, eventually. But, you know, the person did not say, because there are a lot of other things that were beclouding the air, that now the person has now realized that, say, oh, I am sorry. That is all that is needed. So he said, oh, baby, I'm
Am I the only one not hearing Mr. Nyacham?
We are not
everyone.
hearing him. I can't hear him.
Oh wow, Mr. Nyacham, we cannot hear you anymore. Okay, Mr. Nyacham has been logged out. But before Mr. Nyacham comes back, please would like to kindly hear from Ms. Omotayo. We haven't heard from you today. So sorry about that, Ma. Please, Ma, if you are still with us, we would like to get a bit of your thoughts before Mr. Nyacha comes back.
Okay. Okay, thank you, Mr. Dennis. Good evening, all. Not Miss Omotayo, sir, Mrs. Omotayo, and Mrs. Omotayo Mune. So I would like to appreciate Mr. Dennis for the way you've been moderating. I also appreciate the delivery of Mrs. Natalia as well as Mr. Nancha. Both of them are my mentors, so I've learned so much from them and I'm still learning. And I will say, in fact, they've said it all, but I would still like to say little. And I must also appreciate those that presented, the two groups that presented. The presentation was actually excellent. I also learned from you people. And I don't know, there was a time that my network, the network actually threw me off. So I don't know whether what I'm about to say, maybe Mrs. Natalia or and Mr. Nancha, maybe they've actually talked about it, but I would just like to say something, even though most of the things I wanted to comment on, they've spoken about it, but there is this one that I didn't hear that I would like to start from. That's under stages and process in mediation. I think that's the presentation for group 1. So I would like to ask that while group 1, while you were presenting, I didn't hear about to mediation, or was it my network? So I would like to ask, please, did you mention agreement to mediate introduction? That's under stages and processes of mediation, sorry. Maybe anybody from group 1 can speak, please, or even. So was there a mention of agreement to mediate under your introduction?
So.
Hello, please, am I being heard?
Yes, ma'am, you're being heard. So yes, ma'am, there was a point where group 2 presented and their presentation captured agreements to mediate.
Okay, sir, but on that, while group 1 was presenting, I think they discussed stages and processes in mediation, and I think there is introduction. So I just want to emphasize that it is important after introducing yourself, as well as maybe allowing the parties to introduce themselves. Like Mr. Nancha said, that ask them, how would you like to be addressed? At least that will give them some feelings of belonging. Then it is important to confirm at this stage whether the parties have actually signed that agreement. Because if that agreement to mediate, if it was not signed, then it's just like building upon nothing. Because remember that while you're talking about principles of mediation, we have voluntariness. And if you say, okay, this is voluntary, is the party's word against your word. But if that agreement to mediate, that document has been signed, you have to confirm it and even see it. So that will show that parties are submitting themselves to mediation, because you know that mediation is all about the parties, it's party driven. So if it is if the parties are individual, yes, okay, agreement to mediate we have signed, but there are also times that parties might be individual with maybe like a company. So what do? Even if you say, we have signed the agreement to mediate, you have to ensure as a mediator that the person that signs on behalf of that company has the right to sign. So the person that is coming now for the mediation will not be like a cleaner or a clerk a clerk in that company and said, yes, I've signed. So it has to be maybe like a director or that's a managing director or those of that caliber. Does he have the right to sign on behalf of the company? Because if he does not and he signed, then the company cannot be bound by whatever decision that is reached. So that's just the point I want to make on the agreement to mediate. Now, also talking about the career opportunity, I would just advise that it's important that
Omotayo, please, you can put off your camera too.
a step further is also to
You can put off your camera so that we can hear you clearly, okay?
work with them. So up to somebody to achieve in life, let money not come first. If money comes first, then one will not go far. So also in mediation, if we are just starting, we will not say, oh, we want to make it like experts. Have we? So we have to learn from experts. And apart from asking, is it possible to maybe like register? I think in almost all the high courts in Nigeria, we have multi-door court house attached to the high court. So is it possible to go and submit your CV there? And then so that if you apply and then you can become a neutral, then you mix up with them as they are mediating, because theory is different from practical. We are all learning, we are all in classroom, but when we get on the mediation table is another thing entirely. So we have to learn from our mentors. We have to learn from these experts. And when we learn, we get the experience. And when we gather that experience, you see that we will actually, the monies will come later. So we have to do, there's something that in law that we call pro bono services. So we have to be ready to do that. So wherever you are you ready to settle people? Maybe even in your area, like in your area, they are fighting. We are going to police, we'll go to court. As a mediator, you should be able to mediate between them. Of course, you know, it's okay when I mediate, so you come and experience from that place. Some people are also knowing you as a mediator. You tell people, even in the bus, in maybe keke or wherever, your places of worship, maybe churches, how you see people, are you ready to mediate? That is how you gather the experience. And when you have the experience, you see that it is those people that will even recommend you. So we should be looking for opportunities to also work with like mediation institute like Shati. So when we work with them, we learn from them. And with time, we will also get there as they have gotten there. So I think they've said all, but this is just the little contribution from my hand. So thank you very much. It's a privilege to be there. And I've learned a lot and I'm also learning. Thank you very much, sir.
All right, thank you so much, Ms. Omotayo, for that wonderful feedback and contribution from you. We really, really do appreciate you. So, please, Mr. Nyacham, over to you, sir. Sorry, you were having
Okay, thank you very much, Omotayo, for that wonderful contribution. Practically speaking, there are different opportunities. Please, I don't know whether you have questions that we want us to address, but career opportunities, you can be a good investigator. You can be a very good investigator as a mediator, an ADR practitioner. You can be a mediator, you know. Stop it. Who is having meeting? You can be a mediation advocate. A mediation advocate is just like we have lawyers, you have a mediation advocate who can represent clients at the mediation table. So you can be a mediation advocate. If you are a non-lawyer, you can be a mediation advisor. A mediation advisor is someone who also represents clients at the mediation table, but the person is not, he does not have a training as a lawyer. So you are either a mediation advocate or a mediation advisor. That is something that you can do. So you can also be a human resource personnel. You know, sometimes you go to banks, you see people, maybe the cashiers or the people working there, they are very impolite. They don't, they just they just treat people anyhow, and then somebody will say, "Oh, I will never come back to this bank. In fact, I'm going to close down my account from this bank." You know, with your training, you can be a very good human resource personnel. You can be um, you can be a trainer. You can be a trainer. Some of us, we train with different organizations. You can train with different ADR organizations, mediation, arbitration, among several other career opportunities. You can actually, then within the mediation itself, just look at yourself from the profession where you come out from, you can specialize. Let's say you're a medical doctor here. You can specialize in resolving medical related disputes. That's a career opportunity. So others are doing medical work, but when they have issues that has to do with medicine and negligence among several others, they want to see someone who is familiar with their own system, acting as a mediator or in the field. So you can specialize, and then if you are someone who is interested in making peace in the family, you can specialize as a family mediator. For me, I don't actually do divorce cases. So if I'm handling matrimonial causes or family related matters, is for the purpose of settling them. Where they insist that they want to go their way, I say, okay, please, you can look for another person, but I may not continue. I don't want to continue in this journey. So you can be a family mediator. You can be an entertainment lawyer. Somebody, you have our media people with a lot of talents. They have signed this contract, they have signed this one, and the rest of it. Then a lot of conflict erupts. You can be a football. You want to go into games, you want to go into football, you want to go into entertainment, the industry. There are mediation opportunities and ADR opportunities in all of these places. So please, the field is wide, is open. You can earn, in fact, having a conflict resolution skills add value to whatsoever trade or profession. Is it market women? Is it commercial mediation you want to go into that has to do with businesses strictly? Do you want to go? They have mentioned several other, like insurance sector, the insurance mediator. You have several other fields where you can function with these skills. So I will want you to develop. Some of you have had the opportunity to train in other organizations. If you want to specialize, don't just stay with one organization. Acquire skills across so that when it comes to authority, you can have authority in all the fields you have tested different organizations, and then you can now form your own opinion, your own understanding, your own style of doing some of those things. And it's going to be very, very wonderful. I want to say thank you to Natalia and my colleague Omotayo for joining us. If there is no any further question, I want to hand over to, if there are no questions, I'll hand over to Dennis to give us information. Let's say if there are questions, and then we can call it a day.
All right. Thank you so much, Mr. Nyacham, for that wonderful take from you, and also from our other two mentors, Ms. Natalia and Ms. Omotayo. So please, we want to get a few questions from the mentees rather. So please, do we have questions from the side of the mentees? Well, we have just a few people left in the class. But for those who are able to wait till the very end, right, please, do we have questions? I'm sure our mentors are here and willing to take questions. Please, we'll be taking 1 or 2 questions. Do we have questions? Do we have questions? Please, you can drop your questions in the chat box if you do.
You can also drop the question in the training group, in the mentorship group where necessary. And they can put them down and ask it in the next session.
All right, thank you, sir. So in the absence of any questions, all right, we'll be calling it a day. Like Mr. Nyacham said, please, if you still have questions that you want to ask, it doesn't end here. You can put them on the main group, right? And then questions will be compiled and asked during the next session. So we are done with week 2 and we're moving to week 3. I hope you're able to learn a thing or two from the mentors and their overall take on the topic, including from your research. I want to encourage mentees to keep pushing in terms of research, trying to make yourself better. And overall, you'll find out that at the end of the program, you are a better and overall a better mediator and generally a better media practitioner. So with that, we've come to the end of this session. A special thanks to our mentors, to Ms. Natalia, to Mr. Nyacham, and Ms. Motayo. We are so happy to have you in today's session. We look forward to having you in our next sessions and in further quarters, getting to learn from your expertise and your experience. Please, to the mentees in class, do not forget to share what you've learned, fill the attendance, tag JIIPCC, and tag Settlement House ADR Institutes on your posts. Right, let's get the word spread. Let's have people more aware of the ADR space, and let us become better practitioners of ADR. I wish everyone a wonderful night's rest. Do have a wonderful night, and bye-bye, everyone.